Yes, guys. So today it's about the Vibes Cartel, uh, the Vibes Cartel hearing. So as you know, Vibes Cartel was sentenced to 35 years to life. His sentence have been quashed, and now today we want to look at the lacuna in the law, meaning the gap in the law. Because normally when the Privy Council makes a ruling, they would either say that person should be retried or the conviction is quashed. It is never to give back. It's not never to give back our final court a chance to make that decision. However, the Privy Council made their decision that the conviction is quashed, but there is one issue that our final court must answer, and that issue is whether or not the artist should be acquitted or he should be retried. Because as you know, the conviction was overturned for jury tampering. So today's application in the court is all about what is called a habeas corpus. What this does, it deals with illegal detention. So for example, if you're in custody over a certain period of time, then your attorney can make an application for a habeas corpus to the court for you to be released, right? Now, what is actually happening here is that Mr. Vibes Carter's attorney, he wrote to the Department of Correctional Services, and they directed him over to the court to sought advice on the release, because he went over to the Department of Correctional Services to find out if the detention is illegal or what grounds is Mr. Vibes Cartel in custody. All right? Now, the argument put forward is that he has been in custody for a while, and the Privy Council have overturned this conviction. So they're saying that he should be out. However, Mr. Adija Palmer attorney, which is Mr. Buchanan, he opened that his client has been in custody for a while, of course. But what he was actually saying is that Mr. Vibes Cartel case is a tight case. There is a gap in the law, what we call a lacuna in the law. And this lacuna looks at the fact that whenever the Privy Council overturns cases normally, they would just say that the conviction is quashed, and sentence overturned. They would normally send back a case to our final court to make a decision, They would actually, so right at this point, the decision that our final court is supposed to be made is being delayed, and delayed of any kind of litigation or any kind of criminal matter is delayed of justice, because this man has been in custody since 2011. But what Mr. Buchanan is actually saying is that his client, right, should actually be granted the habeas corpus or granted permission to go outside and actually fight his matter or wait until the June 10 hearing, which when I look at that, I don't think the judge said that he's going to school Mr. Buchanan today. But my learned friend Buchanan, if I were Buchanan, what I would say would be totally different. What I would put forward to the judge is that the fact that the Privy Council has overturned the case, it simply means, and technically, my client has been remanded in custody since 2011 and has not been tried. And in the lowest form, that is just inhumane treatment, because he has been in custody since 2011. That's 13 years. And technically, he's not guilty. So I think it is worthy for him to be granted bail and to fight his case outside. And I would also cite his medical conditions and the fact that he has never been convicted before, and he has a family and he's not a flight risk, and he would surrender his travel documents, which I don't think he has any travel document now because his passport would have expired from when, since he was in custody, right? So the argument here now is on June 10th, when the hearing will be held at the Supreme Court, at the appellate court, and the big question that the appellate court has to answer, this is the question that the Privy Council give them to answer. This question is going to be known as the issue. This issue is whether or not the court finds it fit to acquit or retry Mr. Adidja Palmer and his co-defendant. And so the representatives, the attorneys who represent Mr. Palmer and his co-accused, they will have to show good argument why his client should not be retried, why this client should actually be acquitted. And so those are the kind of argument we are looking forward to. But now it's 2 o'clock, after 2 rather, and they're in the Supreme Court now deciding whether or not he should be granted some form of bail, because there's an habeas corpus application. No, but the judge says that he will be schooling everyone in the court. And so, in my opinion, I think that what will actually happen today, and I could be wrong, the judge will actually leave that decision until June 10th, which would be the hearing, the appellate court hearing. So today is not really about anything to do with the appeal itself. It's about the detention, whether or not the detention is illegal. That is what the habeas corpus is for today. It's not anything to do with the appeal per se. The appeal would be that the decision or that issue would be on June 10th. So I don't want anyone to have it confused. So we should come back and actually catch up on this after the court make the decision today. But in my opinion, I could be wrong. This habeas corpus today application that they are making, I don't think they're going to be successful. And on the habeas corpus application, the attorneys, the first respondent is the Department of Correctional Services, and the attorney also wrote to them asking them on the grounds of Mr. Adidja Palmer's detention, and they directed the attorney to the court. And so the first respondent is the Department of Correctional Service. The second respondent, I think, is the Attorney General, and the third respondent on today is on the habeas corpus would be did I say Attorney General, and the Director of Public Prosecution would be the final one. Yes. So 3 of them, and the argument is whether or not the detention is illegal. And so the final point that I want to make is that know that there is this gap in the law. The fact that we are not used to this kind of decision, because normally the Privy Council would either say, all right, we quash the decision, he should be released, right? But they did not say that this time. They said that our final court should make that decision. So now there's a gap between the time, over 2 months now, since the decision was made by the Privy Council. There's a gap between then and now when this guy has been in custody. And what Mr. Buchanan is arguing is that there's nothing in the book to talk about this gap. So I think that our legislative body should jump in now and try to amend what's it called, the Adjudicator Act. I think it's called the Appellate Adjudicator Act. Don't quote me on it. That should be amended now to speak about the time when the offender or the co-accused, when the accused and the co-accused, should speak about the time, the gap between the trial and the decision time. What should happen? That is what the law should actually fix right now. So there is a gap. We call it a lacuna. There is a gap right there that legislative body should fix, because I don't think that anyone should be in custody. Face it, you're in custody over what, 13 years since 2011. Remember, you're not convicted. You're not a convict, right? So technically, you have been remanded in custody for 13 years without trial, and you don't know when your trial is. So I think, in every sense, that is inhumane. And if he's not granted the bail today, granted you, his attorney, if they decide to take it back to retrial on June 10th, then what the attorney will do, the attorney will make another bail application, which would be the right thing to do, depending on how far the trial date would be after this hearing on June 10th. So it is imperative for the June 10th hearing to result, to let us know exactly what is going on, because the main question that has to be answered that was sent from the Privy Council is whether or not Mr. Kartel should be acquitted or retried. There's no other question. They did not respond to whether or not he should be granted bail, whether or not his detention is illegal. They mentioned nothing of his detention. And so the Correctional Service Department has nothing much to say about the detention more than directing the attorney to the court. No, the judge is saying, Justice Andrea Thomas is saying that she's going to have to school the attorneys today. And I think one mistake my learned friend, Mr. Isaac Buchanan, made was when he asked the judge to teach him, or to teach him what he's missing. I think that was my learned friend, Mr. Buchanan. I don't think that was a good idea to ask a judge to teach you. Right? You need to be more, assertive, more confident. You don't need to ask a judge to teach you. Even when you don't know, you pretend as if you know everything. You're the attorney, right? And so my application would be, I would open that my client deserves to be granted bail. The fact that technically he has been remanded in custody for 13 years without a trial. He's not being found guilty beyond a reasonable doubt. And the fact of the matter is that he has an ailment. He has a sickness. He's not a flight risk. He does not have a valid passport and stuff like that. He's a public figure, and he could actually take a bail on condition. The condition could be to report to a police station within his community, or maybe a condition of curfew, which I don't think would be sensible or valid. But I think the other argument would that he needs to earn. He has been in custody and he has not been convicted. He's not a convict as we speak, and he needs to earn for himself and his family for battling this case. And so we are going to catch up back later after we get the decision from the court on what the final word would be on the habeas corpus. Because remember that June 10th would be the day when the trial decision or the acquittal decision would be made at the appellate court. So tune in and let's catch up back later. All right? So guys, I'll see you. Tune in later.